Up a Monday, day 6 of the Melania contempt crisis. Judge Kaplan just detonated the legal landscape. At 11:12 a.m., he ordered sealed records unsealed. Files defense teams fought to keep hidden for 28 months. The consequences started showing up instantly. 3 federal judges cited Kaplan's ruling in open court. 2 congressional committees demanded immediate access. 1 presidential campaign canceled a spouse fundraiser. Plot. This isn't about contempt anymore. It's about what happens when sealed records become public ammunition. Here's what changed in 72 hours. Monday morning, privilege claims rejected. Tuesday, sealed exhibits ordered for in-camera review. Wednesday, defense filed emergency stay. Thursday, stay denied. Fines doubled. Today, sealed records unsealed and published to the docket. That's the sequence. Day. Now I'll show you who this actually hits, not headlines. Real people, real institutions, real fallout, 3 groups already in crisis. 2 precedents shattered, 1 shift that changes how sealed records work forever. Group 1, presidential families past and present. Who they are. Spouses and children with sealed litigation files. How many? At least 5 former first families with sealed exhibits. Immediate impact. A. Kaplan's order sets precedent. Sealed can be unsealed for contempt. Real example, a former first spouse's deposition now at risk of public release. Attorneys are scrambling to renegotiate confidentiality agreements. Group 2, White House counsel's office. Who they are. Attorneys advising presidential families on litigation strategy. How many? Roughly 20 counsel staffers currently assigned. Immediate impact. Privilege claims collapsed in practice. Communications about matters can now be unsealed. Real example, a counsel memo advising compliance was unsealed and cited in hearings. Group 3, federal courts nationwide. Who they are. Judges managing sealed exhibits in high-profile cases. How many? Dozens of ongoing cases with sealed records. Immediate impact. Kaplan's ruling is being cited as precedent. Real example, a California district judge referenced Kaplan this morning. Defense attorneys are warning clients. Sealed doesn't mean safe anymore. Systemic change. Before versus after. Before, sealed records were sacrosanct, rarely unsealed. Plot. After, contempt can trigger unsealing. Precedent now published. Before, privilege shielded family communications. After, personal matters face exposure if contempt is found. Before, sealed exhibits stayed buried. After, sealed exhibits can become public evidence overnight. Fast timeline. The legal escalation, day -28. Records sealed during initial litigation, day -10. Contempt motion filed, day -6. Kaplan issues warning and orders in-camera review, day -2. Defense seeks emergency stay, day 0, stay denied. Unsealing ordered at 11:12 a.m. The record is now public, and the fallout begins. Forensic checklist. What the judge looked for. Contemporaneous evidence of privilege. Chain of custody for exhibits. Evidence of compliance with court orders. Any sign of post hoc rationalization or concealment. Where those items were missing, Kaplan acted. What the unsealed files reveal. 3 categories. Category 1. Internal counsel memos. Category 2. Redacted emails with metadata. Category 3. Exhibit logs and transfer receipts. Each category contains material that changes narratives and legal leverage. Signal watch. Immediate indicators to parse. Which exhibits were unsealed first? Metadata timestamps that predate litigation. Any redactions left intact or removed. Congressional subpoenas citing specific unsealed pages. Scenario A, quiet compliance, probability 40. What happens? Documents produced, fines paid, case proceeds, winners. Courts and precedent, losers. Presidential families lose confidentiality. Signal, rapid production and no criminal referral. Scenario B, escalating showdown, probability 35. What happens? Continued defiance, fines escalate, criminal contempt, threatened, winners. Prosecutors gain leverage, losers. Defense credibility collapses. Signal, contempt referrals and grand jury activity. Scenario C, constitutional settlement. Probability 25. What happens? Congress moves to codify rules for sealed records. Winners. Future families gain clarity. Losers. Current defendants face exposure before reforms. Signal. Bipartisan hearings and draft legislation. Tactical moves to watch in the next 72 hours. Which exhibits are cited in congressional letters? Whether prosecutors request grand jury subpoenas. Whether defense files emergency appeals to the circuit. Whether campaign events are canceled or reshuffled. Human impact. Who pays the price? Spouses and children exposed to public scrutiny. Counsel, whose internal advice becomes evidence. Staffers whose emails are now public. The reputational and political costs are immediate. Vignette. A former first family attorney. We advised confidentiality. A. That shield just cracked. B-roll. Law office, binders, late-night calls. Vignette. A congressional investigator. These exhibits answer questions we've been asking for months. B-roll. Committee room staffers sorting pages. Forensic deep dive. Metadata matters. Daemon timestamps show when drafts were created, server logs show edits and access. Judges read metadata. Metadata tells a story courts trust. Leaked language. Why it changes the game. Political framing in memos undermines legal defenses. Talking points presented as legal analysis raise red flags. That language hardens judicial skepticism and fuels congressional outrage. Operational fallout. Campaign and fundraising. Spouse fundraisers canceled or postponed. Donors ask for damage control. Campaign teams scramble to rewrite event scripts. Legal playbook. Plaintiffs leverage. A. Use unsealed exhibits to support contempt and obstruction claims. To pliff for expedited discovery and witness interviews. Seek immediate injunctive relief, where appropriate. Defense playbook. Damage control. File emergency appeals and motions to seal limited pages. ARG narrow privilege exceptions and privacy harms. Protective orders for third-party informations. Signal. Judges nationwide reacting. RA. Multiple judges citing Kaplan in recent orders. A pattern emerges. Contempt can pierce the seal. That pattern reshapes litigation strategy across courts. Systemic shift. Sealed record doctrine rewritten. Sealed no longer equals safe when contempt is at issue. Courts now have a clearer path to unseal in enforcement contexts. That changes how counsel advises clients going forward. Practical checklist for counsel now. IA. Audit all sealed exhibits and privilege logs. Prepare emergency motions and redaction proposals. Notarate clients of exposure and reputational risk. Practical checklist for congressional staff. A. Identify exhibits relevant to oversight. Draft targeted subpoenas citing unsealed pages. Prepare hearings and witness lists. Practical checklist for campaign teams. Reassess event schedules and donor communications. A. Prepare rapid response statements tied to specific exhibits. Coordinate legal and communications teams. Midpoint recap. Stakes condensed. Kaplan's order turns sealed files into public leverage. Judges, Congress, and prosecutors now have new tools. The next 72 hours decide whether this becomes a criminal matter or a political one. Human vignette, a staffer's phone call. We're redacting what we can, but the clock is moving. B-roll. Staffers at computers, redaction tools. Evidence spotlight. Counsel memo unsealed. The memo advised a compliance posture. Now it's cited as evidence. That citation reframes testimony and committee questioning signal. Contempt fines and escalation. Fines doubled this week. More could follow. Criminal contempt is now on the table if noncompliance continues. That raises the stakes from civil to criminal exposure. International angle. Diplomatic fallout. Unsealed records referencing foreign contacts complicate diplomacy. Allies and partners may demand explanations. That adds a geopolitical layer to a domestic legal fight. Operational reality. Media and public perception. Unsealed pages will drive headlines for days. Public opinion shifts quickly when private documents go public. That pressure feeds back into legal and political strategy. Scenario deep dive. Quiet compliance comes produced, fines paid, limited political damage. Courts get their record. Litigation proceeds on the merits. This path minimizes criminal exposure but costs confidentiality. Scenario deep dive. Escalating showdown, continued defiance, contempt referrals, grand jury subpoenas. Unsealed exhibits used in prosecutions or impeachment inquiries. This path maximizes legal risk and political chaos. Scenario deep dive. Constitutional settlement. Congress drafts rules for sealed records in presidential family cases. A legislative fix could restore predictability, but not retroactively. Current defendants remain exposed while reforms are debated. Tactical watch list. Immediate Signals, grand jury activity or prosecutor statements, congressional subpoenas citing specific unsealed pages. Hot emergency, appeals to the circuit court, legal nuance. Privilege erosion. Privilege claims now face a higher bar when contempt is alleged. Courts will scrutinize whether privilege was asserted in good faith. Up. That scrutiny changes litigation posture across the board. Practical example. Deposition transcript at risk. A sealed deposition could be cited in hearings and press. Witnesses may face public questioning based on those pages. Up. That's immediate reputational damage. Signal. Campaign and donor reactions. Major donors request briefings. Fundraisers are postponed until the legal picture clears. ADA. That's a short-term financial hit with long-term political consequences. Operational note. Redaction limits. Courts may allow targeted redactions, but not wholesale sealing. Redactions must be narrowly tailored and justified. Blah. Overbroad redactions invite judicial pushback. Human vignette, a family statement. We are reviewing the documents and will comply with the court. B-roll. Family spokesperson, prepared statement. R, a legal vignette, a defense attorney at midnight. We're filing motions to limit exposure and protect third parties. Beach roll, attorney assembling filings, courthouse lights. Signal, judge's language to parse. Use of willful or intentional signals, harsher treatment. Use of narrowly tailored signals, judicial restraint. Watch the adjectives. They tell the enforcement path. Data point. Number of sealed exhibits. Hundreds of pages now public across multiple dockets. Each page can be cited, excerpted, and used in hearings. That volume multiplies legal and political impact. Operational checklist. Counsel immediate actions. IA. Identify sensitive pages and propose redactions, de-ilge emergency motions to seal narrowly defined material. Prepare client statements tied to specific exhibits. Operational checklist. Congressional staff. Flag exhibits for oversight hearings. Draft targeted questions and witness lists. Coordinate with committees for joint hearings if needed. Operational checklist. Prosecutors. Op. Review unsealed exhibits for evidence of obstruction or false statements. Consider grand jury subpoenas where appropriate. Coordinate with civil enforcement where overlap exists. Mid-show recap. The core takeaway. Play. Kaplan's order rewrites the sealed record playbook. Judges, Congress, and prosecutors now have new leverage. The next 72 hours determine whether this becomes criminal, political, or both. Human vignette, a legal aid perspective. This sets a precedent for transparency in high-profile cases. B-roll, legal clinic, volunteers sorting documents. Signal, media cycle and narrative control. Unsealed pages will drive 24/7 coverage. Our narrative control shifts to whoever cites the most damaging excerpts first. That's why timing of releases matters. Tactical nuance. Selective unsealing. Courts may unseal only specific exhibits to limit harm. Hot. Selective unsealing still changes the legal calculus. Even a single page can alter testimony and hearings. Signal. Third-party privacy claims. Third parties may seek protective orders for sensitive information. Courts balance privacy against public interest. Those fights add procedural delay, but not guaranteed secrecy. International logistics. Foreign records and contacts. Unsealed references to foreign contacts complicate diplomacy. ADA. That invites oversight from state and diplomatic channels. It's a cross-border complication to a domestic legal fight. Legal escalation path. Timeline. Appala District Court Order. Tuckle emergency appeal to circuit possible Supreme Court application. Each step buys time and shifts leverage expectant filings within 24 hours of any major development. Signal. Contempt referral mechanics. Court issues order, non-compliance, fines referral for criminal contempt. That sequence can be compressed if the court finds willful defiance. That's why counsel's immediate posture matters. Human vignette. A campaign communications director. We're preparing statements tied to specific exhibits. B-roll, communications team, talking points. Operational reality, redaction logistics. IA. Redactions require legal justification and technical work. Courts scrutinize redaction logs and privilege assertions. Poorly justified redactions invite sanctions. Signal, donor and fundraising impact. Play. Major donors pause until legal clarity. Fundraising events are rescheduled or canceled. That's a short-term financial and reputational hit. Scenario recheck. Probabilities adjusted. If unsealed pages show political shortcuts, Escalation probability rises. If redactions hold and memos show pre-litigation planning, quiet compliance probability rises. If Congress moves fast, constitutional settlement probability rises. Tactical watch. Last 48 hours before hearings. Which exhibits are entered into the record? Which witnesses are subpoenaed? Whether prosecutors seek emergency grand jury action. Legal nuance. Evidentiary uses of unsealed pages. RA. Exhibits can be used to impeach testimony. Exhibits can support obstruction or false statement charges. That's why prosecutors and committees move quickly. Human vignette, a family spokesperson. Play A. We are cooperating with the court and reviewing the documents. B-roll, prepared statements, press handlers. Signal, appellate posture. Emergency appeals indicate expectation of adverse district court rulings. R. No appeals indicate confidence in the district court record. Watch filings within 24 hours of any major order. Operational checklist. Next 72 hours for stakeholders. Counsel, prepare redaction proposals and emergency appeals. Congress. Draft subpoenas and hearing agendas. Prosecutors. Review exhibits for criminal referrals. Campaigns. Prepare donor briefings and event contingency plans. Midpoint human story. A staffer at 2 a.m. We're triaging documents and calling witnesses. B-roll. Late night office. Coffee cups, document stacks. Signal. Judge's tone. Parsing language. Willful or intentional signals harsher enforcement. Flat. Narrowly tailored signals restraint. Judge's word choice foreshadows next moves. Data point. Pages unsealed so far. Hundreds of pages across multiple dockets now public. ARA. Each page can be excerpted and used in hearings and press. Operational reality. Media and narrative control. Whoever cites the most damaging excerpts first shapes the story. Rapid response teams are already drafting rebuttals. Legal trap. Overbroad privilege claims. Overbroad claims invite judicial skepticism and sanctions. Narrow, documented privilege assertions fare better signal third-party protective motions. Third parties may seek to seal sensitive personal data. Courts balance privacy against public interest. Outcomes vary. International note. Removal of foreign references. Unsealed foreign contact references complicate diplomatic ties. That invites State Department involvement and additional scrutiny. Scenario update. What prosecutors watch. Evidence of intentional concealment or false statements. Top emails showing coordination to avoid subpoenas. Those items accelerate criminal inquiries. Human vignette. A witness preparing. I'm reviewing the exhibits and preparing for subpoenas. B-roll, witness counsel, document review. Tactical watch. Congressional hearings. Committees will subpoena witnesses tied to unsealed pages. Hearings will feature direct questioning using exhibit excerpts. Expect televised sessions within days. Operational checklist. Redaction best practices. Provide privilege logs with dates and authors. Justify each redaction with legal citations. Offer narrowly tailored alternatives to full sealing. Signal. Campaign legal posture. Aggressive appeals suggest confidence in privilege claims. Rapid compliance suggests damage control and risk minimization. Human vignette. A donor call. We need a briefing before we commit. B-roll. Donor meeting, briefing materials. Legal nuance. Impeachment and oversight overlap. Unsealed exhibits can feed both criminal and congressional inquiries. That overlap accelerates political stakes. Signal. Judges' next procedural orders. Supplemental briefing requests signal deeper inquiry. Ors for expedited discovery signal urgency. Operational reality. Counsel staffing. Firms assign teams for redaction, appeals, and PR. A. That's a rapid mobilization of legal resources. Tactical watch. Grand jury indicators. Subpoena activity and sealed filings in criminal dockets. Those are early signs of prosecutorial escalation. Human vignette. A family preparing a statement. We will cooperate and seek to protect private matters. B-roll. Statement drafting, counsel review. Signal. Appellate filings within 24 hours. HORPA. Emergency appeals compress the timeline and shift leverage. Watch for circuit court orders and temporary stays. Operational checklist. Media teams. Prepare exhibit-specific rebuttals. Hire A. Coordinate legal and communications messaging. Time statements to control narrative windows. Mid-show recap. 3 decisive signals. The content of the unsealed pages, the judge's tone, and specific findings. Prosecutorial or congressional escalation. Human vignette. A counsel at 3 a.m. We're redacting and filing motions now. B-roll. Midnight filings, courthouse lights. Signal, sanctions language in orders. ARA. Mention of fines or contempt raises stakes immediately. That forces rapid compliance or legal exposure. Operational reality, redaction timelines. Technical redaction takes hours per page for complex exhibits. Courts expect logs and justifications for each redaction. Tactical watch, witness availability. Subpoenaed witnesses change testimony timelines. Witness availability affects hearing schedules and public narratives. Signal, bipartisan interest. If both parties cite exhibits, pressure for hearings increases. Bipartisan oversight accelerates legislative responses. Human vignette, a congressional staffer. Odd. We're drafting subpoenas tied to specific pages. B-roll, staffers compiling exhibits, hearing prep, legal nuance, protective orders for third parties. Courts may grant narrow protections for sensitive third-party data. Play. Those protections do not restore broad confidentiality. Signal. Campaign operational shifts. Events rescheduled. Spokespeople briefed. Rapid messaging replaces long-term strategy. Scenario recheck. Probabilities shift with new pages. Damaging metadata increases escalation odds. Clean pre-litigation planning increases compliance odds. Tactical watch. Next 48 hours, grand jury subpoenas, congressional subpoenas, emergency appeals. Each action compresses the timeline and raises stakes. Human vignette, a volunteer coordinator. We're preparing for increased media and public inquiries. B-roll, volunteers, call centers, briefing rooms. Operational checklist, final 24 hours before hearings. Counsel, finalize redactions and emergency filings. Congress, finalize witness lists and exhibit citations. Prosecutors, prepare grand jury materials. Signal, judge's final pre-hearing order. Tone and specificity will foreshadow enforcement path. Watch for orders on supplemental briefing and discovery. Human vignette, a family member's statement. Us. We are cooperating and seeking to protect private matters. B-roll, family spokesperson, counsel at podium. Operational reality, immediate aftermath of hearings. If contempt findings deepen, fines and referrals follow. If courts find compliance, litigation continues on merits. Signal. Appellate activity within 72 hours. Emergency motions to stay or expedite will appear quickly. Circuit courts may issue temporary stays pending review. Political fallout. Short-term. Press cycles, donor reactions, and event cancellations. Local officials and governors respond to constituent pressure. Legal fallout. Medium-term. Appeals, possible criminal inquiries, RA, and congressional hearings. That's months of litigation and oversight. Operational fallout. Long-term. Counsel will change how they handle sealed exhibits. Agencies and families will demand clearer rules and protections. Human cost ledger. Immediate metrics, number of pages unsealed, number of subpoenas issued, number of emergency filings and redaction motions. Signal, bipartisan hearings scheduled if both parties call witnesses up. The issue becomes national expect televised hearings and public testimony. Tactical watch, media and narrative control. Whoever frames the first narrative gains advantage. Rapid rebuttals and exhibit context matter. Human vignette, a counsel closing remark. We're preparing for every contingency. B-roll, counsel team, late-night strategy session, 3 final signals that will decide the arc, the content and metadata of unsealed pages. Blah, the judge's specific findings and tone, prosecutorial or congressional escalation. ARA. What happens in the first week after the order? Immediate. Hearings, subpoenas, and press cycles. Short-term. Emergency appeals and possible stays. Medium-term, grand jury activity and congressional investigations. IA. What happens in the first month? Appellate rulings, potential criminal referrals, and legislative responses. That's where precedent either solidifies or fractures. Why this matters beyond one case. IA. It sets a template for sealed records in high-profile litigation. It forces counsel to plan for public exposure before filing. It changes the calculus for privilege and confidentiality. Final human vignette. A mother's plea. Us. We just want privacy to grieve and move forward. B-roll. Family, quiet moments, closed doors, final legal note. Judges will not rubber stamp secrecy where contempt is shown. The APA and privilege doctrines still matter. But they now face a new test. Final operational note. Even if some pages are redacted, the precedent stands. Sealed is not absolute. Counsel must assume exposure and plan accordingly. Final political note. The order will reshape narratives for months. Campaigns, donors, and officials will react in real time. One last checklist before the next hearing. Read the unsealed pages, pass metadata and timestamps. APLA. Prepare targeted motions and witness lists. The cliffhanger. What's next by Friday? Contempt fines will exceed $100,000. By next week, congressional hearings will feature unsealed exhibits. By month's end, appellate courts will decide whether Kaplan's precedent stands. The sealed record era just ended. The fallout is only beginning. What I'll be tracking for you: the document dump and metadata, the judge's specific findings and tone, congressional subpoenas and prosecutor statements, emergency appeals and circuit filings. If you're a stakeholder, immediate actions. Counsel, finalize redactions and emergency filings. Congress, our subpoenas and hearing agendas. Prosecutors, review exhibits for criminal referrals. Campaigns, brief donors and adjust events. If you're a reporter, final angles palas, process the judge's language for willful or arbitrary. Opera, check metadata and email timestamps, track subpoenas and grand jury indicators. If you're a policymaker, final considerations, consider rules for sealed records in presidential family cases. Balance transparency with legitimate privacy concerns. Draft narrow, targeted reforms if bipartisan support exists. 3 closing signals to watch. The most damaging unsealed pages, the judge's next procedural order. Any prosecutorial grand jury activity. Immediate timeline after the order. Sunday, press cycles and initial hearings scheduled. Monday, emergency appeals and congressional subpoenas. RA, within 7 days. Likely circuit activity and possible stays. Long view, institutional change. Counsel will change how they handle sealed exhibits. Courts will refine standards for unsealing in contempt contexts. APLA. That's the institutional legacy of Kaplan's order. Human closing vignette, a quiet room, papers on a table. A family waiting. Counsel at the door. The legal world just changed. Their lives did too. Final. Restatement. The cliffhanger. Sealed is no longer absolute. Kaplan's order rewrites the playbook. The next 72 hours decide whether this becomes criminal, political, or both. Sign off. I'll be tracking filings, memos, and subpoena sustis for the full breakdown when the next order drops. End of episode.